the principle of the presumption of innocence and the European Convention on Human Rights, a safeguard of a fair trial and an obstacle to the death penalty. We have no doubt in asserting that the presumption of innocence is an assurance of the respect of human dignity. As we will try to show, human dignity is the basis on which any construction of human rights is based. And the presumption of innocence is an assurance of respect of those human rights. It is respect for this principle that legitimizes the state's criminal intervention in the collection, production, and evaluation of evidences. But let's clean us up all this. At this point, we'll briefly explain what human dignity is and what human rights are, and why the presumption of innocence is an assurance of respect for those human rights, or even a type of human rights. What is human dignity? The first reference came with the Universal Declaration of Human Rights. Given the historical moment after the end of the Second World War, the human dignity emerged as a recognition of an inalienable and common right to all human beings, as a foundation for freedom, justice, and peace. However, its genesis is earlier. It comes from the Catholic and Christian doctrine of the man in the image of God, Imago Dei, a concept that imposes a sense of equality among all human beings, equality seen in several senses that will grant them inalienable. It is the secular image of human dignity in his religious belief. Man is a unique creature and thus traces an idea of moral superiority of human in relation to the other species existing on Earth. It was also this sense of equality between men that in 1789 triggered the French Liberal Revolution. With the Enlightenment spirit, it emerged as an embryo of a natural human right, liberté, égalité, fraternité, as the foundation for placing man at the center of everything and everything, self-limiting and democratically taking responsibility for the tripartite divisions of powers. In Kant's perspective, man is an end. Man is priceless, cannot be assigned a value or even replaced. And such a conclusion comes from the inherent equality, dignity. For as an autonomous being that we are, they are, everyone is, each one will be able to develop his personality, always distinct, and each one of them irreplaceable and individual. These are the characteristics that assures man the exclusivity of dignity. It cannot be said that dignity of human beings is a right. It's rather a principle, a value, necessarily abstract. As Hannah Arendt says, it's a right to have rights. It was human dignity that establishes an ethical minimum that all men will hold. However, with such a natural vagueness, it turns out to be a beautiful but hollow vase. Dignity is the glue that brings together the rights protected in the Universal Declaration on Human Rights. The different acceptations that human dignity implies, with or without religious or secular connotations, with a concrete philosophical interpretation, is also revealing of the pluralism that that value is in itself. A value that can be understood in different ways, but that everyone understands to be a value that we all hold. Human dignity imposes, as can be seen, respect for each person's choices and options, but if those choices can be tolerated and admitted while still respecting that same condition. This is being the way of building human rights. By this, human rights functions as assets that man can use against the description of political power of each state. As Jorge Reis Novaes says, it means making the whole construction of the rule of law based on an idea of an unavailability of fundamental rights by the public authorities. It is a principle and consequently value vague. It's not a litigation argument. of the law, and consequently dignity are not invoked in this way so pragmatic. In the European Convention on Human Rights, ECHR, there is no literal indignity. There is no express reference to human dignity. Despite the absence of literality, it is unequivocal that dignity is inherent to the ECHR for several reasons, but right away because the ECHR refers to the Universal Declaration on Human Rights. We believe that the ECHR is an instrument of an international nature in protection of individual interests. But with the creation of the ECHR, this law, this international law, is intended to have an objective application and consequently a more practical, more procedural nature, while the Universal Declaration is an informative and remarkable text within the scope of the Universal Consecration on Protection on Human Rights. It works like jus cogens, an imperative rule of international law. Do not forget that it was approved by acclamation. When something tends to be concession is lacking, the concept of human dignity is immediately sought. The association of dignity and human rights with the presumption of innocence begins to appear in the need for its evocation to the use of man as an object of public worshipability, even if legitimated. It arises in the sense of limiting the punitive power of the state, respecting the dignity of human being, and thus the need for the presumption of innocence. César Beccaria, with his classic work, refers to the presumption of innocence as a fundamental value of respecting the defendant's dignity in criminal proceedings. In this enlightenment and classic and referenced work regarding the protection of the accused and the legitimation of the application of penalties, the author writes, "A man cannot be found guilty before the judge's sentence, nor can society take away his public protections unless he violated the established pacts." It's not just a rule of probative nature that in the face of the non-liquid of the judge, it should make his use favoring the defendant. But before real mean of the defense of the defendant, who despite being accused in a criminal case is a person and deserves always the protection of its dignity as such. It remains to figure the content that what CHR sees or configures of the presumption of innocence. That is what we will try to explain next. Everyone charged with a criminal offense shall be presumed innocent until proved guilty according to law. This is the original text of paragraph 2 of Article 6 of the ECHR, in which enshrines in law the principle of the presumption of innocence. What we will try to do next is the attempt to draw an interpretive line of such a norm. In several and multiple decisions, the ECHR and the European Court on Human Rights has marked out the content of the principle of the presumption of innocence, defining its contents and its consequences. The presumption of innocence that is typified in this second paragraph is an assurance of a fair, equitable, and impartial trial. This presumption of innocence has several implications at various points in the criminal proceedings, but with a special focus on evidential law in criminal proceedings. It appears as an assurance of a fair, impartial trial that should always live without prejudice of guilt or criminal responsibility to the accused, and that remains through the process. A neutral position that should be followed not only by the court in the process, the proceedings, but also by the public authorities. A requirement that is made in number 1 of the 6th article of the ECHR, in the sense of the existence of a fair and impartial process. The importance of this neutrality and innocuousness is such that even when the lawsuit is closed because of the lack of proofs or reasonable doubts, the presumption prevails. It shows that in the ECHR, the presumption of innocence is understood as a true guarantee that is attributed to the defendant, which is effectively implemented by the ECHR, especially when there is no procedural pursuit. The presumption of innocence is only seized with the final condemnatory sentence. The other forms of closing the process do not allow a derogation or elimination of this principle. However, without the existence of criminal proceedings, there is no violation of the presumption of innocence. In other words, it is understood that the presumption of innocence is only valid pending criminal proceedings and remains even if the decision is an absolution or the impossibility of continuing the process, for example, with the death of the accused. However, there is a violation of this principle in the preventive measures of a non-criminal nature that precede the criminal proceedings. Finally, regarding the media, in trying to measure the right to information, freedom of expression, and the presumption of innocence, the ECHR has come to impose a line of interpretation of this section of Article 6, that there are certain barriers that cannot be overcome by the media. Thus, there may be a violation of the presumption of innocence using certain expressions and blame by the media. These are two conflicting rights, since freedom of expression and consequently freedom of press are protected in the very text of the Convention on Article 10. One of the conditions of a free, democratic, and open society is that freedom of expression and right to information are verified. To limit this right in an excessive and unlimited way would also annihilate some basic guarantees of healthy and free living in community. But almost nothing in law is absolute, is forever, always needing a consideration of this practical application. In this way, often harsh statements in the press are accepted in a democratic society, given the public interest that they may be at stake. These are two rights that are difficult to reconcile, but the court is responsible for ensuring their maintenance and enforceability. On the other hand, in the sense of the nemo tenetur and the right to be silenced, to prevent the use of deceptive means, the ECHR has understood that the scope is effectively assurance that right do not make statements and prevent the police from obtaining the statements that the defendant is making. In the court lines of the interpretation regarding the right to be silent and its violation will depend on the analysis of all the circumstances of this specific case, and not the way in which national courts protect or not the prohibition of self-incrimination, as a consequence of a fair trial and therefore reinforcing the presumption of innocence. In a conclusive way, we say that the nemo tenetur si ipsio accusare and the right to be silent have their source in the ECHR, in the right to a fair trial. However, they are also a way to secure the presumption of innocence. In fact, in our understanding, it's the correlation between the acceptance of the presumption of innocence with these two rights that make the humanistic scope of this very important international law. And a conclusion can be drawn from this. The accused is free to decide to cooperate with criminal investigation, renouncing his right to be silent and consequently his presumption of innocence. In this context, the human dignity is highlighted as an assurance of control of the action of the states when using one of their strongest powers, the judicial power, by privating freedom. Thus, human rights appear as assets that man will use against any action and that jeopardize his dignity. So the scope of the presumption of innocence and the way that the ECHR is guiding his interpretation of this second paragraph of Article 6 is clearly an obstacle to the death penalty. The right of a fair trial, the respect of the defendant as a person, makes consequently the death penalty an exception. Successively, society creates new ways of understanding the rule of state and the rule of man in these states. We open the possibilities to these constructions, but always guided by one of the main limits of criminal actuation, the presumption of innocence as a manifestation for the free and conscious exercise of human dignity. Thank you very much for your attention.